You've definitely seen it in movies and on TV a million times. You have the right to remain silent. But what if that right doesn't quite work the way you think it does? Today, we're going to dive into what the right to silence really means in Canada. And trust me, it's a story that's a lot more complicated than a simple catchphrase. Right, we've all heard the line. The police read a suspect their rights, and the suspect says, "I'm not talking." In the movies, that's pretty much the end of it. Conversation over. But what if it isn't? What if the police can just keep talking, keep trying to persuade you, keep asking questions even after you've made it clear you want to stay silent? Well, that exact question actually went all the way to the Supreme Court of Canada. And look, this wasn't some abstract legal debate. It was a real and frankly tragic case that forced our highest court to draw a very, very difficult line. So let's get into the case that brought this all to a head, R.V. Singh. So the story starts back in 2002. The crime itself was just awful. There was a dispute at a pub that spilled outside, shots were fired, and a completely innocent person, Richard Loff, was killed. The police investigation led them to Jagrup Singh, and they brought him in for questioning. Now, this part is absolutely crucial. Mr. Singh knew his rights. He was told he could talk to a lawyer, and he did. He spoke with his lawyer on the phone and even met with him in person right before the interrogation started. So he walks into that interrogation room, fully aware that he doesn't have to say a word. And he made that crystal clear, over and over again. Before he said anything that could be used against him, he told the police he wanted to exercise his right to silence 18 times, 18 separate times. He was saying things just like this: "I don't want to talk," or "I have nothing to say," or "I want to go back to my cell." It couldn't have been clearer. But the interviewing officer, he just kept going, presenting evidence, encouraging him to talk, trying to get him to change his mind. And this, right here, is where the legal fight really begins. Singh never actually confessed to being the shooter, but after saying over and over that he wouldn't talk, he eventually did identify himself in some surveillance photos from the pub. Those statements became key pieces of evidence for the prosecution, and he was convicted. So the million-dollar question for the courts was, should those statements have even been allowed? So what this case really did was set up this kind of legal collision course between two really important principles that are meant to protect people in police custody. You've got this old common law rule, and then you've got this newer constitutional right from our Charter of Rights and Freedoms. Let's see how they stack up. Okay, here's where it gets really interesting. On one hand, you've got the old school confessions rule. It basically asks, was the statement voluntary? Did the police threaten the person, or was the environment so oppressive that it just broke their will? On the other hand, you have the newer charter right to silence. And that's asking a totally different question. It's asking, was the process fair? Did the person have a real, meaningful choice to speak or not? They sound similar, but their focus and who has to prove what are totally different. And that difference is everything in this case. So how did the Supreme Court of Canada deal with this clash? Well, the decision was, to put it mildly, incredibly close. It really shows just how divided the country's top judges were on this. By the slimmest possible margin, 5 judges to 4, the court sided with the police. Jagrup Singh's conviction was upheld. But the real story here isn't just who won or lost the vote. It's in the why, because their reasoning completely changed the game for the right to silence in Canada. Okay, so the majority's whole argument boiled down to these two words, functionally equivalent. Basically, they said, look, our modern confessions rule is already so tough. It requires the Crown to prove beyond a reasonable doubt that there was no oppression, that the suspect had an operating mind, that it automatically protects the right to silence. In their view, if a statement is truly voluntary, then by definition, the right to silence must have been respected. No need for a separate test. And this quote from their decision really sums up their thinking. They were trying to strike a balance. They were really worried that if they made the right to silence an absolute off switch, it would just hamstring police investigations into serious crimes. So they argued that police have to be allowed to use legitimate persuasion, as long as it doesn't cross that line into coercion and take away a person's free will. But, and this is a huge but, remember, it was a 5-4 split. 4 other judges on the highest court in the land saw things completely differently, and their dissent was, well, it was powerful. The dissenters just flat out rejected that functionally equivalent idea. For them, these two rules were apples and oranges. They argued that police could do something that was unfair and violated a person's charter right to make a choice, even if that conduct didn't quite meet the high legal bar of oppression under the old confessions rule. And This line from their dissent, wow, it just cuts right to the chase. Their whole point was, if someone tells you 18 times they don't want to talk, and you just keep hammering away at them, is their choice to finally speak really free or meaningful? The dissent's answer was a hard no. They believe that kind of relentless pressure can make you feel like giving up is your only option, which isn't a real choice at all. For these 4 judges, this wasn't just about police procedure. It was about honoring the Constitution. They saw the right to silence as this fundamental promise from the state to the individual. And it's a promise that, once you claim it, should be respected, not something the police can just try to wear you down on. So the dust settles, and the majority's decision is now the law in Canada. So what does all this actually mean for an average person? You know, if you ever found yourself in that room, what are the practical takeaways here? All right, let's break this down. This is the bottom line. First things first, saying I want to remain silent in Canada does not legally force the police to stop talking to you. It is not an off switch. Second, they are allowed to keep going with what the court calls legitimate means of persuasion. But there is a line. They can't become so oppressive that they completely break your will or make it so you don't have an operating mind. Ultimately, if you do end up talking, a court will look at the whole picture, how many times you said you wanted to be silent, and how persistent the police were, to decide if what you said was truly voluntary. And that really leaves us with this massive, unresolved tension at the very heart of our justice system, doesn't it? The Singh case is a perfect example of a system trying to balance 2 really important things: giving police the tools they need to investigate terrible crimes and protecting the fundamental rights of every single person. The Supreme Court drew a line in the sand, but as that 5-4 split proves, it's a line people are still fiercely arguing about today. And it forces us all to ask, in that constant balancing act between solving crimes and protecting rights, where exactly should that line be drawn?